Welcome, everybody. My name is Marty Mascari. I am with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center. I'm a contractor with them, and both of those are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We are once again blessed to have our friends and partners at Heyman Hogue to talk to us today about the truth about wills, trusts, and estate planning. But before we get started, I'm going to go over the CEU requirements with you all. So if we could advance to slide one. There you go. Thank you so much. So for those of you that are joining us today that are looking for CEUs and CLEs, today's a thank you to Heyman Hogue, who is providing the CEUs and the CLEs today. For those of you that want to get a CEU or a CLE or a certificate of attendance, you need to be on the webinar for the entire webinar and the Q&A afterwards. Then you're going to get 2 documents, and I don't know, sometimes there's 3. You're going to get 2 or 3 documents from me in a follow-up email. One is but the 2 that are really important is the evaluation form and the sign-in sheet. Both of those you need to complete and send to Sheila. And I just realized I usually let Sheila do her part of this, and then I do mine. I'm so sorry. I'm so sorry. I'm very sorry. I'm so used to doing this. Do you want to finish your part, or do you want me to just keep going?
The only thing I wanted to say is the 3rd document is just a disclosure to tell you that we do this for a living, but that's not why we're doing it today. We're doing it strictly to educate. This is not to sell you anything. This is strictly to educate so that A, you can help your patients or clients, and B, well, in some cases or a lot of cases, you can help yourself as well. So that's it.
Very good. Very good. Well, you need to, you're going to need to get those 2, that email, the first follow-up emails will go out within about 24 hours, and that will have the documents attached. So you need to complete those documents, take a picture of them, scan them back in, what you need to do to get them to email them back to Sheila. And we're going to give you 1 week to do that. It's just, you guys, working on the CEUs one person at a time is incredibly time consuming. And so we're going to start putting, we have limits on all the other ones. We're making that limit here that you got to accomplish that between now and next Thursday to get those back in to qualify as part of your qualifying. If you wait till after next Thursday, even if you have a problem, we're not going to reopen it back up again after Thursday. It's just too time consuming, and we can do a lot more good by putting these on for a lot more people than chasing down one or 2 CEUs here and there every week. So please get that back for ASAP. Additionally, there is a Google survey that will pop. It should give you the chance to go to it actually as you close out of Zoom today. But if not, you'll also receive the link to that survey as well. We ask that you complete that survey because that helps us to report back on the goals and objectives we set forth when we applied for the funding to bring you these webinars. So that being said, I'm going to let Sheila, since I stole all of her time, let Sheila introduce Fred or say whatever she wants for a few minutes to get her time back, and then introduce you to Fred.
Well, this is funny because neither Fred and I don't feel well at all. I have a massive sinus infection, if you missed earlier in the chat, and Fred probably has the same. So, but we're doing the best we can to get through everything. And I just put a cough drop in my mouth so I wouldn't be coughing as I'm talking to you. Anyway, today we are going to study the truth about wills, trusts, and estate planning. And the reason Fred likes to give this, and the reason it's called the truth about that, is because you hear a lot of different things, either from family members or TV or whatever. and you think you may know things, and you muddle through, and then you get into a problem and you don't know what you should do. So we want to make sure that you understand what these documents are, what you may need in terms of need to know about, and why. The resources are there for you to reach out to people. And then you can, if you find yourself, yes, I am. David, thank you very much. He sees all the medication I'm on. That's fine. Anyway, if you find yourself in a conversation or a situation, maybe you can help a patient, a client, or a friend reach out to the people that they need to talk to. This is my boss, Fred Heyman, the founding partner of Heyman Hogue. Been an attorney for 27 years, certainly knows these subjects backwards and forwards. And so, but he is a Texas attorney, as it came out earlier in the questions. That doesn't mean that he can't refer you to help in your state, but these are the basics that he's going to give you. And then if you need help in another state, I'm sure he'd be glad to refer you to somebody. But without any further ado, Fred Heyman.
Real quick, if I could add
Yes,
one thing. I am in the center of the storm. I'm sure Fred's houses north of here, he knows we're in the storm zone that's supposed to come through anytime. So if you lose me, just keep going on. I should be able to get back on, but it won't disconnect you if you lose me.
Okay. Hopefully I didn't know it's sunshine in here. I didn't know.
Yeah, we're supposed to have some storms come through here pretty quick.
Okay.
Okay.
Well, good afternoon, everybody, and thank you for joining us. I think we've got like 167 people on today, it looks like so far. I do enjoy doing this presentation because I enjoy educating. I enjoy helping people understand a complex, difficult topic that it's very hard to understand if you're not a lawyer. It's honestly hard to understand if you are a lawyer and you don't do this area law. So the law has become so much like medicine in that there's specialties in every area, and people get their expertise in certain areas. And so estate planning and elder law has become one of those areas that are so complex that it's very difficult to get through. But today I'm going to try to simplify it as much as possible. I'm going to try to get through the basics. Like Sheila said, we're kind of talking at a Texas level, but every state has estate planning. And we are members of a group called Wealth Counsel, which is tied to attorneys all over the United States. So I actually was last weekend up in Colorado Springs visiting with two Colorado attorneys that we're working with. So if you need any a reference from your state, I'll be more than happy to help you. So let's just jump right in. What exactly is estate planning? Now, I'll be honest, I don't like the term estate planning because people, when they think of estate planning, they think of money, they think of their stuff, they think of passing on their assets. And when you look at the definition, that's what it talks about. It's examining your financial need and assets and who are the heirs and who are they going to get it. But I look at it more as family protection planning, because to me, I've never had a group that I've talked to that I didn't ask, what's the most important thing in your life? And none of them tell me their money. None of them tell me their house, their cars. Yeah, we like our stuff, but the most important thing in our life is our family. And so why wouldn't you want to put plans in place that protect that family in the event of incapacity or in the event of death? And so a lot of the stuff we focus on, we call it family and money protection planning, because we're looking at both. We're looking at how do we pass on your assets. We don't want to forget that, of course, but how do we put things in place to simplify your family's life if something comes up? So when you look at planning, there are several options people can choose. Most people want to choose option number one, but that's not reality. I want to spend every penny I have and I want to die completely broke. Well, if we knew exactly how much money we had and exactly how long we had to live, maybe we could do that. but that's just really impossible. So some people look at, I can die intestate. Intestate is just a fancy legal term for dying without a will. We're going to talk about the documents that you need, but at minimum, everybody needs a will, because if you don't have a will, the government has a will for you, because every state government has written laws that put into place how things pass and what happens and how it goes to the family if you die without a will. So at minimum, you want to put a will in place. You can put things in joint tenancy. Joint tenancy is allowed in some states. It is not in Texas. And it's not allowed in a lot of other states. Joint tenancy is where you put property in the name of two people, usually husband and wife. And if one dies, the survivor inherits it all automatically. It passes outside of probate. It just automatically goes from the deceased person to the survivor. Texas does not allow that. Texas is a tenants in common state. So you need to find out what your state is. But a tenants in common state says husband owns 50%, wife owns 50%. If husband dies, it doesn't automatically go to wife without going through a legal process called probate. And that process is going to court, hiring an attorney, paying legal fees, usually $3,000, $4,000, $5,000, and going through the process of getting somebody appointed, either as an executor if there's a will, or as an administrator if there's not a will, and passing everything on. So if you can put things in joint tenancy in your state, I highly recommend it. But if you're in a state like Texas where you can't, you have to have proper planning in place. You can create a will, and a will is good, but a will is not great. A will has limitations. A will can do nothing more than give your stuff away. It can't have stipulations. It can't carry on beyond death. So for instance, I can't say, I want my brother to be able to live in my house until he dies, and when he dies, my house goes to my kids. You cannot do that in a will. You have to do that in a trust. So depending on what you want to accomplish, that's why it's so important to talk to a professional estate planning attorney so that they can tell you what the proper mechanisms are that can be used to accomplish what you want to accomplish. You can create a bare bones estate plan. And I use that term because there's way too many organizations, the internet, other places that try to sell people a one-size-fits-all estate plan. There is no such thing that works properly as a one-size-fits-all. Just think about your family compared to your friend's family, compared to your brother and sister's family. No two families are alike. No two families have the same goals. No two families have the same amount of money, the same amount of children, grandchildren, blended family, second marriage, whatever. So a bare bones estate planning that is designed to fit everybody fits nobody. So I don't recommend that at all. Or you can create a complete family and protection plan. And what that is a plan that's done by a professional that knows what they're doing, that custom designs it specifically for your family. So I always tell my clients, I know the law, but I don't know you. I don't know what your goals are, your objectives are. I don't know what your family structure is. I don't know what your financial structure is. So once I find all that out, let's design something specifically for what your family's like and what you want to accomplish. So when you design a plan, you need to think of certain things. Number one, we are a lawsuit happy America. We have more lawsuits in this country than any other country in the world. So designing a plan, you need to think about, do I need to do asset protection? Do I need to put things in place that will prevent me from losing everything if I get into a lawsuit? The number one reason for lawsuits are car accidents. The number one thing every single one on this presentation does. We all drive. And so if that is a concern, you need to think about that. There also is over 1 million bankruptcies filed every single year. The number one reason for bankruptcy are medical bills. So do you want to put a plan in place, or do you need to think about things like that? Do you need to put a plan in place that thinks, well, I don't have to worry about that, but wait a minute, when I leave it to my children, do I need to worry about that? Do I need to worry about giving assets to my kids and them going through bankruptcy and losing everything I left them. So those are the type of things you think of in those regards. Every year, 50% of marriages end in divorce. I always say that I want to leave my daughters. I have two beautiful daughters. I have a 21-year-old and an 18-year-old. Yes, God is mad at me for the years I had in college. He's paying me back with two beautiful daughters. But those two beautiful daughters will get married someday. And yes, I wish they live happily ever after. But the chance is 1 in 2 of them may not. And I don't want to leave an inheritance to my daughter only for half of it to go to my future ex-son-in-law if their marriage doesn't work out. So there's plans in place you can do to prevent that. Nursing home care. I could talk about this for 2 hours. Nursing home has gone out of the roof. The costs have gone crazy. So do you need to look at planning that protects you from losing all your money if you were to go into a nursing home or a family member was to go into a nursing home? This is the saddest one to me. Approximately 70% of Americans don't have a plan. And what I mean by don't have a plan, they either have not done anything at all, they've done something and it's 20 years old. I can't tell you how many times I get people to come in, oh, I did, my husband and I did a will when my children were 2 and 3, now they're 25 and 26. You know, you can't put it in place and expect it to last forever. They put a plan in place in California and now they're living in Texas. So there's many, many reasons you might have either no plan or an inadequate plan that you think you're protected when you're really not. Over the years, I've done this so many years, I put together 6 major concerns that my clients have come up with as we've gone through this. And I apologize for drinking, but I hope I don't lose my voice before the end of this presentation. The number one concern, and if there's anybody on this webinar that doesn't agree with this, you'll be the first one I've ever met, because everybody wants to figure out, how do I do a plan to keep the government and the courts out of my life? Nobody wants the government in their life. Nobody wants the courts in their life. So how can we put a plan together that does that? In Texas, one of the biggest misconceptions I see, and I'm maybe jumping ahead of myself, and there may be a slide later that I've not remembered, but one of the biggest things I get in Texas is, oh, I have a will, so we're not going to have to go through probate. That is not true. A will makes probate easier, but it doesn't avoid probate. So when you have a will in Texas, you have to go through the probate process when somebody passes away. I always say that a will should not be called a will. It should be called a wish, because a will is nothing more than a wish until a judge looks at it, accepts it, puts it into effect, appoints the executor, and gives the executor authority to carry it out. Then it becomes a will. Most states are like that. There are a few states that you don't have to probate a will, but that's few and far between. Number 2, how do I avoid paying unnecessary taxes? I wish I could tell you how to avoid paying all taxes, but if you did, you'd be going to the federal penitentiary. So everybody has to pay taxes in some way, shape, or form. But a good plan is designed so that you only have to pay the absolute necessary taxes. I always use the story, one of my favorite stories in the Bible. They asked Jesus, should we pay our taxes? And he says, well, whose face is on the coin? And he says, Caesar. And Jesus says, well, you pay Caesar what is Caesar's, you pay God what is God's. Our job is to pay Caesar only what we have to pay Caesar, and Caesar makes the rules. So a good estate plan uses Caesar's rules to your advantage, not Caesar's advantage. So you want to make sure you put a plan in place to avoid any unnecessary taxes. As I said earlier, I can go on forever about this one. How do I avoid going broke because of nursing home or medical expenses? This is a special type of planning, usually a Medicaid planning type process, but there are things that can be done. And I talk to clients every day about, okay, do we want to plan for this? Do we not want? What are the other things that we can do? There's other options out there like long-term care insurance. If you can't afford long-term care insurance because it's gone so expensive, there's actually other policies out there now that I call them single premium policies. They're policies where you can move money. If you, let's say you have money saved up, you can move 100,000 from one account to this, and it gives you long-term care coverage. So there's other options out there in the planning process that can help this if this is a concern in the future. Number 4, how do I protect my family against predators and creditors? How do I keep people that are trying to take my family's money from taking it? And that's a good, solid plan. So there's plans in place to protect your assets. Some states, like Texas, have a lot of natural asset protection laws in place. So for instance, Texas, our house is our castle. If I sue you, I can't take your home. The home is ultimate protection. Other states are not that way. I think California has a limit. It has a certain amount, a dollar amount. Over that dollar amount I can get if I sue you. You need to know what those laws are in your state so that you can put things in place to properly protect against predators and creditors. Number 5, this is one that hits home with me very strong because prior to being a lawyer, I was a police officer out in El Paso, Texas for over 5 years. I handled so many family fights that I told my wife at the time I would never live in a house with 58 in the address because I heard code 58 so many times that I never wanted to hear it again because a 58 was a family fight. Family fights, every family is dysfunctional at some level. And if you want to find out how dysfunctional, have somebody die and leave some money. Not just a lot of money. I've had family fights over minimum amounts of money. So what can I do to put my plan in place to prevent family fights? I take a lot of pride in the stuff that we put together that dramatically reduces family fights. And I always tell people, I can't avoid somebody from suing you. I can't avoid an idiot from challenging something if they want to challenge it, but I can't avoid them from winning. And I can't avoid them from having a good chance of getting into court, if going to court at all. And lastly, this is one that does hit really hard to my heart because a lot of people think about doing their estate plan to pass on their stuff, but they don't pass on them. They don't pass on a legacy. I highly encourage my clients to do things like write stuff down or do a video of their life. There are companies out there that will come in and videotape your testimony that you can pass on to your kids and grandkids and great-grandkids. And I highly recommend that. I had a father who was a major in the United States Air Force during Vietnam. He was in a division called OSI, Office of Special Investigation. He was a military spy. A lot of his life was top secret. So a lot of his life, I don't know anything about. I remember growing up and my mom saying, well, we don't know where dad's going. We don't know when he'll be back, but he's going to be okay. I remember being a teenager asking him about what he did in Vietnam and him saying, I can't tell you. I wish he would have documented some of that to pass on to myself and to my daughters so that we knew a little bit more about dad. And so I highly recommend doing this as part of your estate plan. So why don't people do this? Why don't people put plans in place? God bless America, home of the free, land of the procrastinator. We are all procrastinators at some level. Please don't procrastinate till it's too late. I always tell people, as long as you're alive and as long as you're well, you can do your plan. But if either one of those is affected, we're in trouble. And I get these calls all the time when it's too late. If you wait till it's too late, the only thing you're doing is an attorney a big favor because we make a lot more money cleaning up the mess than we do doing it right in the first place. So please don't procrastinate. The second reason people don't do this is a lack of knowledge. And that's why I do these presentations. If you don't know about something, it's human nature to avoid it. We all do that in every shape and form. So people avoid doing their plans because they just don't understand it. They don't understand the process. They don't understand how complicated it is. They don't understand what to do and how to do it. And so educating yourself is very important. The internet is good and it's bad, but the internet, I get people all the time say, well, I've been doing some research on the internet, and then I'll walk them through saying, okay, this part that you read about is correct. This part is not. So let's clear it up, but let's make sure that you know all the right answers before we make a decision for your family. This is the typical estate planning scenario for many, many years. You would go to your accountant to do your taxes. You would go to your financial advisor to do your investments. You'd go to your insurance salesman to do your insurance, and you'd go to your lawyer to do the legal documents. And none of those mixed. We don't believe in that. And a lot of attorneys I work with all over the United States have changed that philosophy, in that we need to know everything about you. I need to know about your taxes. I need to know about your insurance. I need to know about your investments, so that I can properly wrap legal documents around that to protect you. I had a lady come in one time that I was asking her questions, and I said, do you have an IRA or 401k? And she says, yes, I do. And I said, can you give me an idea how much you have in there? And she said, oh, I don't want to disclose that. I don't want to share that. And I said, well, then I can't help you, because if I don't know what you have, I can't put proper documents in place to protect you. And so you need to go hire somebody you can trust telling them that information, because if you don't trust me, then I can't help you, and you need to go somewhere else. So you have to be able to pick somebody that you feel comfortable with, that you trust, because the law is a lot like everything else. You know, I go to a doctor, I got to trust that that doctor knows what they're doing. I go to an architect, I'm going to have to trust that he knows how to design my house. So same thing with a lawyer. You've got to pick a lawyer that you're comfortable with. I tell my clients I have two requirements of you. You have to like me, because we're going to see a lot of each other. And you have to trust me, because you're going to have to tell me a lot about your family so that I can put proper things in place. I love this picture, the McDonald's of estate planning. Poor plans do so many bad things and cause so many problems. And again, not to emphasize it, but poor planning costs money and makes attorneys money, because poor planning can have all these kind of things in it. No long-term care protection, no family protection, no remarriage protection. So one of the things that I talk to my clients about is, okay, if you passed away and your spouse got remarried, are you concerned that they'd give the estate away? Do we need to think about that? Now, I call that the Anna Nicole Smith protection. So there's all types of things that you need to think about as you go through this. And if you don't think about it and you do a do-it-yourself or a one-size-fits-all, you're going to miss out on all these great things that plans are built to protect against. This is my consumer warning. What are those public service announcements? Please, please, please don't just depend on doing it yourself over the internet. The internet has no regulations like lawyers have. I am legally obligated to do a good job for my clients. If I don't, I can get sued, and I actually have to carry legal malpractice insurance, like a doctor carries medical malpractice insurance, in case that happens, because I have a legal obligation to my clients. The internet has no legal obligation whatsoever. And years ago, I thought about doing my own website, because I had so many people coming in with documents they did over the internet that were terrible. And I got really frustrated, and I said, well, maybe if I put a website together that does minimum Texas compliant documents, at least I know people that did it, do-it-yourselfers, they would at least get minimum good documents. And so I called the State Bar of Texas, and I left a message with the ethics attorney, and the ethics attorney called me back, and she said, Mr. Heyman, I understand what you want to do, and you said you wanted to be completely compliant with State Bar regulations. And I said, yes, ma'am. And she started laughing. And I sat there for a minute, and she said, well, Mr. Heyman, I'm not laughing at you. I'm laughing at our wonderful Texas legislature. Because apparently, and this is how she put it, she said, apparently, LegalZoom has gotten to the legislature before you could. Because hidden within our Texas government code is a law called Unauthorized Practice of Law. And it says, if you are buying internet documents you are not practicing law, or if you're selling internet documents, you're not practicing law, and therefore you're not compliant and don't have to do anything an attorney does. She says, the way she put it, she said, if you're selling legal documents over the internet, you're doing nothing more than selling a product. And that product can be good or bad, and it doesn't matter because the client, the customer, has no recourse. She said, it's like you selling a pen over the internet. And I said, okay. So I get off the phone and I thought about it. And I thought, if I sell you a pen, how do you know when that pen works? When you use it, right? If I sell you a will, how do you know when that will works? When it's too late. And you don't know if it works. Your family finds out it doesn't work when they have to probate it after you pass away. So all these companies have to do to get away with that is have a disclaimer on their website. And so here's two of them that I found. LegalZoom has a disclaimer basically saying we're not a substitute for an attorney. We're not a law office. We're not lawyers. Rocket Lawyer, which is another big one, they say we're not a law firm. We do not review these information. You're on your own. And so all they have to do is publish this and they're off the hook. They have no liability and you can't sue them if they screw up. So please have somebody do it that knows what they're doing. I always tell people, I'm the best at saving money. I always look for a bargain. Don't look for a bargain in this area. Spend the money to do it right. Excuse me. So what documents does everybody need? And this is true no matter what state you live in. You need two areas of documents. You need living documents and you need death documents. The first in the living documents are the financial documents. You need a statutory durable power of attorney or a power of attorney from your state, however it's done, that allows somebody else to make financial decisions for you if you can't make them for yourself. So this document allows people to pay bills, allows people to talk to the bank, talk to your employer, talk to your 401k manager, talk to anything and everything to do with finances if you've done it right. This is the document we have more problems with than any other document. If this document isn't done right, you're going to have major problems. This document has to be comprehensive. If you do an internet document or if you just do a simple one that's 2 or 3 pages long, I'm guarantee you it's going to have problems. Our documents are 10 to 15 pages long because I want my document to say everything it needs to say. So no matter who has to look at it, they don't have a reason to decline it. And just think about this document is only as good as the people you give it to. So if I have to use my mom's document, let's say my mom is sick, I have to take care of her. I have to go to PNC Bank. I give them their power of attorney. They're going to review it. I go to Bank of America. They're going to review it. I go to Chase. They're going to review it. Every single one of them has different rules and they review it under different things. And they're all looking for what they want. And if it's not there and they deny it, it's as if you never had it. So please, if you don't do anything comprehensive, do this one. This is the one I have most problems with. The second area of living documents are your healthcare documents. You need documents so somebody can make medical decisions for you, medical treatment decisions, talk to the doctors. You need documents where your family can get your medical information, your medical records. So we do a medical power of attorney. We do advanced medical directives, which is also called a living will or directive to physicians. It's all the same form. That form is different than a DNR, do not resuscitate order, because a DNR is a don't touch me at all order, whereas an advanced medical directive is a I want you to treat me, I want you to make me well, but if you've tried everything and you've exhausted all means, and the only hope is either keep me alive on life support or let me go, I decide which one I want. I decide while I'm well, if I become unwell, do I want to be kept alive on life support or do I want to be let go? You need a HIPAA form. Now, I recommend doing a universal HIPAA form that's good anywhere, because if you go to the doctor or you go to a hospital and you sign their HIPAA form, it's only good at that location and it's written in their favor, not in your favor. So you want to make sure you get a universal HIPAA form that's good anywhere. You want to do a declaration of guardian in case of future incapacitation. This is a form that says, if I become totally incapacitated and somebody needs to become my legal guardian, who do I want that to be? So I name my guardian instead of the courts naming my guardian. Now, some of you all might be from a state that flips it. So I always say that it's a flip-flop. There's a term called guardian and there's a term called conservator. In Texas, a conservator is in family court and takes care of children. I become a conservator of my niece or nephew if I need to care for them. In Texas, you become a guardian of an adult who is incapacitated. Some states, they flip-flop that where you're a conservator over somebody incapacitated and you're a guardian over children. So check on your state to see what that is. The great thing I like about this form is it also allows you to name who you don't want your guardian to be. So if you've got troublemakers in the family or if you've got people you don't want to burden, you disqualify them with this form. So those are your living documents. Now I call them living documents because they live with you and they die with you. These documents are not good once somebody dies. They're void upon death. So they're only good during life. I highly recommend that everybody looks into this company called DocuBank. This has nothing to do with my firm. I've been using DocuBank for 15, 20 years at least. DocuBank is an online storage of these forms. DocuBank allows you to upload your healthcare forms, your medical power of attorney, HIPAA form, directive, and they send you a credit card. Looks kind of like this, and you carry that in your bank, in your wallet. And if you're in a car accident, they know exactly what your allergies are, what any medical conditions you have, who do you want to contact in case of an emergency, and then it also tells them how to download those forms, the medical power of attorney, medical directive, HIPAA form. The cost of DocuBank is, to me, minimal. It's like $150 for a 5-year membership. And I highly, highly recommend it. So all you need to do is look up DocuBank on the internet and you can sign up and do that. But I really think it's a great company and I carry it in my wallet right behind my driver's license. So let's talk about the death documents. Everybody's heard of the last will and testament. So we all know we need a will. We'll talk a little bit more about that. There are a couple other documents I recommend. You do a designation of representative to carry out the remains. That is who is in charge of your funeral arrangements. That is important, especially if there's a dissension in the family. I've got some families where they say, well, I want to be cremated, but my daughter, her religious belief, she doesn't believe in cremation. We want to make sure that the daughter's not in charge then, because we want somebody in charge of your funeral to carry out what your wishes are. So we appoint somebody to carry out your wishes. I also highly recommend that people consider a pre-need funeral arrangement. That's where you go and you arrange it and you pay for it all ahead of time so that your family doesn't have to worry about it. They don't have to think about it. They don't have to pay for it at the time, and they don't have to make the decisions. You've already made all the decisions. We do an anatomical gift form for people that want to donate their organs, either for medicine, science, or organ transplant. A lot of states like Texas allow you to tell DPS on your driver's license that you're an organ donor, but this form is a lot more specific as to exactly what you want carried out. The last form is what I call the living and death document, and that's a trust. People that aren't familiar with trusts or people that have heard trusts, and I'll be honest, this is the way I was before I became a lawyer, is trusts are for the rich people. Trusts are for the wealthy. Trusts are for people with special circumstances and a lot of stuff. Not everybody needs a trust. That's not true. A trust is not a trust is not a trust. So a trust can be designed for you and your family that'll benefit you and your family. And it gives you, a living trust gives you advantages during life and advantages after death. And it allows you to be creative where a will doesn't allow you to do that. So there's all different types of trusts. Excuse me. But your most common trust is a revocable living trust. Revocable meaning you can change it, you can modify it, you can add to it, you can subtract from it. Living trust means you put it together while you're alive, and it's good during life. It gives life benefits, but it also has death benefits after you're gone. There are also different types of trusts that we do for tax planning, for asset planning, for Medicaid planning. It depends on what you want to accomplish. You can talk to the attorney about that. But I'm going to talk a little bit about your main issues of trust. There's, like I said, there's 4 main types. There's a living trust, which I told about is good during life, created while you're alive. There's also a testamentary trust. A testamentary trust is a trust you put in your will. So the will says, when I die, I want this trust to go into place. A lot of attorneys push that, and I guess I understand kind of why, but not really, because a testamentary trust is not good during life. You get no life benefit. You have to probate the will to put it in place usually, and you're putting the burden on somebody else to set it up after you die. So I'm not a testamentary trust fan. We don't do very many testamentary trusts. When my clients talk to me about wanting things that are beneficial with the trust, I talk about a living trust, because you might as well put it in place now and get the benefits of it now and not put that burden on somebody else. And a revocable living trust that's set up properly will avoid probate. It passes all your assets outside of the courts. So revocable versus irrevocable, all it means is, can I change it or can I not? A revocable living trust allows you to change it during lifetime. An irrevocable trust is like the 10 Commandments. We chisel it in stone, and it's almost impossible to change without court interdiction or without special arrangements of some kind. It's very difficult. We do irrevocable trust for special things like asset protection, like Medicaid planning, those kind of things. So let's talk a little bit more about a living trust and why you'd want to think about a living trust. A living trust, if it's set up properly, and again, think about a trust as a contract. A contract is only as good as how well it's written. That's why when you buy a house, you've got pages and pages and pages of contracts, because they want to make sure they cover every possible thing that could come up. A trust is the same thing. The better a trust is written, the more protections it's going to give you. So not all trusts are created equal. Not all attorneys that do trusts are created equal. You want to make sure that the trust is properly written to avoid certain things like guardianship. Guardianship, like I said, is when an incapacitated person needs a legal person to take care of them. So in Texas, you can avoid guardianship kinda by having power of attorney, medical directive. If I become incapacitated, my spouse can take care of me with those documents, and they work fine as long as I cooperate. If I stop cooperating, they could have major problems. And I had a big case in El Paso when I was practicing law out there, where a daughter had taken care of her mom for years. Daughter had not had any problems until mom's Alzheimer's got to the point of paranoia. All of a sudden, mom thought daughter was stealing all her money and daughter wanted her dead. Mom's mind was gone, except it wasn't gone enough to not call the doctor. She still had the doctor's phone number. She called her doctor and said, "Do not talk to my daughter. She wants me dead." The doctor knew that wasn't true, but because mom verbally revoked her medical power of attorney, she couldn't honor it anymore. Mom called the bank and said, "Daughter is stealing all my money," and verbally revoked her power of attorney. Overnight, daughter went from being taking care of her mom to nothing. She had no authority over mom at all. Mom, all she had to do at that point is do a guardianship. So we had to go through the whole guardianship process, which is a good $10,000 to $15,000 process in the legal system, just to give daughter the same authority she had before mom got paranoia, so that she could continue to take care of mom. A properly drafted trust will avoid that, because it says, in essence, I give permission to my spouse, to my brother, to my daughter, whatever I do, I give them permission to take care of me even if I don't cooperate. Now, they have to jump through certain hoops, and they have to have certain medical proof that I'm incapacitated. We don't want somebody abusing it. But once I'm incapacitated, once that's been established, the trust allows them to continue to manage my money and continue to manage and take care of me. A good trust, a properly done trust, and a properly funded trust can avoid probate. And what I mean by properly funded is, think of a trust as a treasure chest. I build my clients a treasure chest. Now they have to hold their treasure in it. How do we hold our treasure? We put it in there. We deed our house into the trust. We align our accounts to the trust. We align our financial accounts to our trust. So as long as the trust is holding or set to catch whatever assets I have, then I don't have any assets. And if I don't have any assets and I die, I don't have an estate. And if I don't have an estate, there's no need to probate. So a good drafted trust will avoid probate. I always tell people, I'm proud to tell you, I'm not worth one penny because all of my value is in my trust, not in me. So I always finish the presentation off with this. Please don't be this person. Please don't listen to this presentation. Take all this information I've given you, get your CLE or CE credit, and don't do anything with it. Please take it and do something with it. I love this quote by Picasso, only put off until tomorrow what you're willing to die having left undone. So please take some action in what I've done. Use this information to help yourself, use this information to help your clients, or use this information to help your family. One of the things that we always offer is a free consultation for anybody that wants to talk about this. And that includes anybody out of state. If you want a phone call, I can talk to you and I can set you up with somebody outside of Texas. I'll be more than happy to do that. But if there's any way we can help you and I can answer any questions for you, you will have Sheila's information after this. And so she gets questions all the time after these presentations. I love to answer them. I love to help people. We also have free reports that we give out to people on estate planning, on asset protection. So if this is in your slides that you'll get, if you want any of these free reports, all you have to do is let Sheila know and she'll send them to you. So I've talked long enough. I am done. I'm going to let you guys talk from now.
Okay. We have
a lot of time left. So
okay,
I'm going to, because, yeah, we've got 38 minutes left. So I'm going to let you go ahead and do the Q&A, and then I'll do the CEs later.
Thank you. Okay. Okay, Fred, we've got so many questions.
And that's why I figured I try to
yes.
get through it because we usually have more questions than anything.
Yes. Okay, first one, and folks, I try to do these in the order that I saw them. Okay, Rita wants to know, what trust do I have to report to the state for Medicaid renewal? I was told only the self-funded trust needs to report.
Now, again, that's from state to state. And I think that's correct, except I would say that's more of an accountant question than it is a legal question when it comes to that Medicaid. I'm not really sure about the answer to that one, if there's any other, but I think you're right on the self-funded for sure. I don't know of any right off the top of my head that you have to report.
Okay. The next one is from April. Can a will include a life estate to live in a house, be given to a child, and then the property be given to specific grandchildren upon the death of the child with the life estate?
Not in Texas. Not in Texas at all. I don't know about other states, but I would guess not, because wills aren't designed to do that. So that's where a trust comes in for sure. And I've talked to attorneys all over, and I've never heard anybody share with me that they were allowed to do that with a will. I don't think it's allowed at all.
Okay. Now the next, going over here. Okay, all the way go all the way back here. Oh, come on. Okay, it is, first one is from Shauna. She has a lot of questions, but I think they got very personal. So is a beneficiary allowed to be included in the probate, or can the executor refuse them and decide to not give them any info until the estate is complete?
Okay, every state has laws that say at what point the beneficiary has to be notified. Now, the beneficiaries always have to be notified at some point. Now, when that is, depends on the state law of what it says. So, for instance, in Texas, I think we were just talking about this the other day. In an heirship, if the person passes away without a will, the heirs have to be notified at the beginning. And with a will, the beneficiaries have to be notified after the executor's been appointed. But they can't just leave it out. They can't just ignore. A beneficiary has to be notified at some point.
Okay. The next question. When trustees are listed in a will, when trustees are listed in a will for minors, are they required to remove themselves as a trustee once the minors are adults?
Okay, say that again.
When trustees are listed in a will for minors, are they required to remove themselves as a trustee once the minors become adults?
Okay, so if they're listed in a will, again, the will doesn't go into effect until after death. And the trustees, and I think you're referring to a testamentary trust inside of a will. The testamentary trust should give direction as to when the trustee's duties expire. If the trustee is not, if it says these are the trustees of my minor children, then yes, when the child's 18, once they're an adult, they can become their own trustee unless it says otherwise. So again, that all depends on how well it's written. I've had testamentary trusts that said, I want my sister to be the trustee of my children's trust until they're 25. And once they're 25, they can get access to their money. So it really depends on what it says. And if it's vacant of any instruction, then once a person's 18, they're in charge of their own money.
Okay, Rosemary wants to know, she made a will about 10 years ago. Does she need to update it?
Yes, ma'am. I would say at minimum, you need to go see an attorney and have it reviewed. I once had an attorney who used this kind of analogy, which I thought was very appropriate. He said, estate planning documents are like a gallon of milk. You know, when you buy milk in the grocery store, it has a date on it. And when that date comes, it doesn't mean the milk's automatically bad. But the longer you wait after that date, the more chance you're going to have sour milk. And so estate planning documents are the same way. The older they get, the less effective they are, and the more chances you're going to have issues with them because the law changes. Everything is changing. The one constant in life is change. So we recommend that our clients review their documents every 3 to 5 years. On average in our firm, we make about 20 to 30 changes to our documents every single year. These are law changes. These are legal strategy changes. These are rule changes. These are changes that sometimes our clients will come to us and say, they had something happen. We're like, whoa, we didn't think about that. We didn't cover it. So we put it in our documents. So there's always kind of updates and changes. So every 3 to 5 years is a good rule of thumb of when you want them reviewed.
Okay, Adrian asks, I have a special needs adult daughter who may not be able to live fully independently when we are gone. We also have an adult son. Both are in their 20s. We just got a confirmed diagnosis for our daughter, so we are in uncharted and unexpected territory.
Okay. I'm not sure what the question is there, except usually when you have a special needs child, once they're 18, they're an adult. And if they can't care for themselves, we do what's called an aging out guardianship. We do a guardianship to allow the parents to become legal guardians of an adult child and continue to take care of that child. That legal guardianship is not nearly as expensive as a guardianship of somebody with Alzheimer's, dementia, or other incapacity. They're usually a couple $1,000s to get that done through the system. And that would allow you to continue being their parent. Depending on their capacity, though, if they have, I had one just the other day in Denton County, the judge wouldn't grant our guardianship because the investigator to the court believed that the child had enough capacity to sign a power of attorney and a medical power of attorney. I disagreed. I'll be honest. It's an autistic child, and I think that they understand a little, but not enough to know what the legalities of these documents are. But the judge would not let the parents become guardians. They wanted us to do estate planning documents instead. So you need to talk to an elder law or guardianship type attorney. And you need to put estate planning in place so that that special needs child never inherits something. And what I mean by that is an outright inheritance to a special needs person will kick them out of any government benefits they're qualified for. So it will kick them out of SSI, SSDI, I can't remember which one's earned and not earned. I think it's SSI or Medicaid. So you want to do your estate planning so that any inheritance you leave to a special needs person is put in a special needs trust for their benefit. It allows that money to be used to care for them, but it doesn't kick them out of government benefits. So I hope that helps a little, but I really highly recommend you talk to somebody. Sheila, did we lose you?
Oh, we did. Okay. We lost Sheila.
Marty,
I'm so sorry.
do you have access to the questions?
I do. I have access to some of them. And I don't know which one she's covered or not, but if a son lives in another state that has inheritance tax, does that apply only to the inheritance left by the son to others, or inheritance we living in Texas leave to their son?
It both ways. So if I leave inheritance to my son in a state that has a state tax, inheritance tax, I have to be worried about that. So that is something that you need to look at in planning. It affects both what they inherit and what they leave. That's why everybody needs to live in Texas.
They're working on that. They're working on that.
No kidding, huh?
They're working. Hey, Elisa, yes, this will be available. I just put the slides in the link for the slides in the chat again, but there'll also be a second email that goes out. There's 2 follow-up emails. The first one has the CEU stuff, but the second one has a link to the recording once we get it uploaded to our YouTube channel. This one, how can a will ensure that a child of daughter's spouse, unrelated to the daughter, will not receive any assets left to our daughter?
A will not do that. So that's where trusts come in. And I do more trust work than I do anything else, because a trust is the best thing ever invented. And I'm not saying that because that's what I do for a living, but I truly believe they are the greatest things ever made, because it allows you to do things you can't normally do. A will can't do anything more than give your stuff away. So if I give my stuff to my daughter, it goes to her and she can do whatever she wants with it. If she goes through a divorce, they can fight over it. If she leaves it to in her estate plan to her husband instead of my grandkids, she can do that. There is no stipulation whatsoever. So with the trust, I can say, I want my daughter to have it, and I can even put it in what we call a heritage trust. And that heritage trust, it goes from my trust to her trust. Her trust is protected against lawsuits, creditors, bankruptcy, and divorce. So it can't be taken from her in a divorce. I can also say that I want it to go to my daughter, and if something happens to my daughter, I want it to go to my grandkids. And so you can do all kinds of creative things with a trust you cannot do with a will.
It said, and you guys may have done this one already. I wasn't tracking that close. Well, there's Sheila right there. She's back. Do you want to pick up, Sheila? Are you in a place to pick up, or?
Well, yeah. Which ones did you answer while I was gone? I'm so sorry.
Just a couple of them at the bottom of the chat.
Okay.
I was going through the chat backwards because I couldn't remember where you were. I'm over at the Q&A right now. did you get to April's question about the life estate?
Yes, yes.
Okay, so then, so I was going from the top down there. So you might do that.
Okay,
And then
I'm
leave off-
trying to the chat now. I'm only seeing the new ones.
Okay.
I can't see
Oh,
the.
yes.
I
Yes,
tell you
yes,
who
yes.
it should be. I
Okay.
have Joshua, Fred. I remember the question basically. Joshua said, "What do you mean by if it's too late?" And I answered him that you were talking about either being incapacitated, mentally incapacitated, or dead.
Yeah.
And he said he wants to know who would determine mental incapacity.
That's a medical determination, but I make an informal determination all the time. So if I have somebody bring mom into my office, dad into my office, I ask them a lot of questions. And if I don't feel that they are well enough to understand what I'm talking to them about, I won't do their documents. And I usually do this presentation doesn't have it, but I usually do a couple of misconceptions. And one misconception is I can have somebody do a power of attorney after they're mentally incapacitated, because I get that question all the time. I'll get the call that says, I just had to put mom into a memory care and I need to bring mom in to do a power of attorney so I can take care of her finances. And I have to tell them, if mom's in memory care, it's too late. I can't help it. I can't help mom because mom's not going to understand what she's signing. And if she doesn't understand what she's signing, I can't do it. And so I get those all the time. And then I get another misconception that they're good beyond death. So I'll get the call that, oh, my dad passed away and I have his power of attorney, so I'm going to get into his bank account and pay his bills. And I have to tell him, no, you're not, because if you use his power of attorney after he's gone, then you're committing fraud and you're going to go to jail if you're not careful. So those documents are good if they're put in place. I always tell people you need to have documents in place before you need them. And if you don't have them in place before you need them, when you need them, it's too late.
Okay, Suzanne asks, can you please answer my question about owning a home 50-50 with my elderly mom?
All right.
If she dies, will ownership automatically go to me, or would my siblings have access? Oh dear.
And I'm going to clarify that this is a Texas answer,
Right.
because every state is different. In Texas, whenever people own a house together, they own it in tenants in common, meaning they each own a percentage of however many people own it. So if two people own a house, whether it's husband, wife, whether it's mom and daughter, it's 50-50 ownership. And when one dies, it doesn't go to the survivor. That 50% passes however they want to pass it. So if mom has a will, that 50% will go whatever she says in her will. If mom doesn't have a will, that 50% will pass however intestacy laws say they pass. But it doesn't go to the survivor.
She has a will. Her mom has a will from 25 years ago when she and I did not own homes.
And the will says it goes to all the kids?
No, just her and her mom is what she said. 50-50.
Okay, so whatever the will says, that's where her half will go. And I've had this happen more than once. I've had it happen to where a daughter and mom owned a house together. Mom died, but she had an old will that gave it to all 4 kids. So now what we have is we have daughter that owns half. We have 4 kids that inherited half, 25% each. So she gets one of those 25%, but now she's still partners with her other 3 siblings. And it causes major issues, especially if the families don't get along. So I always tell people, don't assume by putting your kid's name on the deed that that's who is going to get the house. They're not. You need to make sure that you talk to a legal professional about how exactly you're setting it up. We do other things like ladybird deeds. Ladybird deeds is like a life estate deed where I can say, okay, I'm going to keep it right now and I want to own it with my son. And my half is a life estate deed so that when I do die, I want it to go to my son. You can do that. So if it's properly set up, it can be done right. But Most of the time, it's not properly set up, unfortunately.
Elsa wants to know if my sisters and I have property left to us from my parents. It is for propriety. Can the grandchildren or great-grandchildren inherit this, and how do we handle it?
For propriety, I'm not sure what you're
I don't know that either. That's what it says.
So property goes to who it's said to go to. And typically, if one of the children dies before the parents die, that children's percentage goes to the grandchildren. But it doesn't automatic. So it's not like, okay, mom and dad passed away, left it to us kids. Does it automatically go to our kids? No, you have to do estate planning to decide where it goes. So I can't totally answer that question without knowing all the facts.
Okay, so there's so many questions here, and they're coming so fast.
Yeah.
One question is, they want to know, can you include property if property owned in Mexico in your trust?
Yes, but we don't recommend it because we don't know what the international laws and how the country that you own property in will honor a United States document. So I used to practice in El Paso for years. I had a lot of clients with property in the United States and Mexico. I would always tell them, you need a United States trust to take care of your U.S. property. You need to go see a Mexican attorney and get a Mexican trust to take care of your Mexican property. And I tell that with everybody, no matter, I mean, I've got clients from all over the world. And so you want to make sure that you do documents in the country where the property is owned.
Okay. Does a trust allow you to claim homestead on your property with the county?
Yes.
Texas? Okay.
You don't lose that in Texas at all.
Okay. Well, that's probably all of that. Okay. I can't, Marty, I can't see the ones from before.
I just emailed you an email with all of them. I just copied and pasted all. It's
Okay.
a little bit hard to read, but so let me see if I can go back. There was a couple of them here. There were a couple of them that are getting pretty in depth into your personal case. It's just more than what we're set to do here. So you're gonna, and I have to make sure I make the comment of, Heyman Hogue does this for us, and we certainly appreciate it. You can use it, as Sheila said at the beginning. They do this for education purposes. You can use any attorney that, and again, like Fred said, you want to make sure the attorney is educated or set up to do estate planning. But you can talk to them. But also you can talk to Heyman Hogue as well. And so, but for those of you that have put the in-depth information in here, please reach out to an attorney.
Real quick, Marty, I just saw a question that said, I have several companies requiring their form be done and don't accept an MPOA or DPOA. Insurance companies and annuities and pension all require their form. So,
Yeah, that was one I wanted you to answer.
Yeah. Sometimes that happens. I don't like it. I don't agree with it. But I always tell people there's a difference between the law and the rules. And some companies have their own rules, and they will want a form done from their company. Now, I've never had one that we couldn't get them to accept our form if the person wasn't able to sign their form. For instance, a daughter taking care of mom's annuity because mom is now in nursing care and incapacitated. And the company says, well, we require our own form. And we have to tell the company, well, mom can't sign your form anymore. Mom is not capable anymore, but mom did her own power of attorney. I've always gotten them to accept it. So they prefer their form and they want you to use their form, but we have been able to get around it. So I hope that answers that question. I did see another one, a family planner in Maryland. If you'll email Sheila, I'll get you some names. I need to know where in Maryland you are, and I'll get you some names.
All right. Sharon emailed Marty because she doesn't have the way to do a chat. She has a question on an adult competent person who has a trust in their name and wants to have the trust dissolved because the one assigned to monitor the trust is not following through with provisions set up in the trust. The trust also is very general and says for the person's education, medical, and well-being. The trust was set up to prevent the spouse of the one who the trust was set up for from having access to the money. The person who the trust is set up for and their spouse are both still living, and the person who set up the trust for their loved one is now deceased.
Okay, I'm gonna have to give you an attorney answer to that one. I need to look at that to be able to really tell you what to do. But it sounds like you need to hire an attorney to modify and work on that because it may require going to court. There could be some stuff that needs to be done. But you need to consult with somebody, a professional on that one.
Shauna asked several things, and the case gets pretty in depth. But Shauna, I'm going to recommend that that maybe you email Sheila afterwards, or there's, depending on what county they're in. Dallas County has both a department within the DA's department, district attorney's office, plus they have a program that they partner with Senior Source on that deals with abuse of seniors for their financials, and will actually prosecute if someone's doing something that they shouldn't be doing.
Thank you, Marty. Yeah.
Those are the two things. Go ahead. I'm sorry.
I have one that says we have a special needs trust set up for our son. Do we need additional trusts, one for each child, others? It's highly recommended that you set up a trust for you and your family, and that trust can have sub-trusts or extension trusts, however you want to say it, to where when you pass away, it goes to the children in trust. That's another one that you want to talk to a professional about, but yes, it's highly advised that you consider it. Because just having a special needs trust has such a limited purpose, it really doesn't provide protection for you or your other children.
Shelley asked, if you have POA, can you set up a living trust for your parents?
Yes, a lot of times, yes, you can. If they're not able to set it up, but you have their power of attorney, I do that all the time, yes. If it's in the parents' best benefit to you, yes, you can.
There's several questions about recording. Yes, we are recording this. Yes, a link to the recording will be available to anybody, but it will go out to everybody who registered in a second follow-up email. So you get the recording and a link to the slides as well.
Okay, I've got one that says, where do you begin? You begin by talking to a professional in this area that will give you a consultation and kind of walk you through. I have a different, so some attorneys charge, some don't. My attitude has always been, I don't want to charge somebody to figure out what they need to do. So I don't charge for a consultation, but that's where you need to start. You need to get an attorney and have a consultation and kind of walk through you, because in my first consultation, I need to learn a lot about you and your family and your stuff, and you need to learn about what options are available. And so that's where you need to start. I also have a question. What is the average cost to have an attorney look at documents? Again, that depends. Some attorneys charge a fee to review documents, some don't. So you need to call and ask, depending on where you live.
Melissa wants to know, you've mentioned this several times, but I guess you didn't probably explain what it is. The affidavit of heirship.
An affidavit of heirship, I don't think we've even talked about.
Well, you did mention it a couple times in the,
Okay, so an affidavit of heirship is a document that's usually used to pass property from a decedent to the heirs. It's drafted and signed by independent witnesses that know the family. It has some really good uses and it has some limitation uses. I use them a lot, but there's a lot of times I don't recommend it because an affidavit of heirship doesn't go through the courts. It doesn't have authority of the courts, so they can be challenged by title companies and people like that. So it all depends on whatever the situation is of whether I recommend an affidavit of heirship.
Well, you don't have a choice if the person dies without a will, though, right?
No, Sheila, you're thinking there's an heirship proceeding.
Oh, that's
then
what
an
she, I
affidavit.
think that maybe that's what she thought.
Okay, so
That's
an
what you mentioned.
an affidavit of heirship is trying to pass property outside of the courts.
Oh,
Sometimes you have to do an heirship proceeding when somebody dies and you go to court and you have the judge bless off on who the heirs are. And that's much more, that's a much better process to go through the courts than not go through the courts, but it's more expensive, of course.
Melissa, that's what he mentioned. Okay, that's what it was. Sorry. Yeah. That's why I don't answer these questions, Fred. Anyway, and one person, I just remember what the question was, said that they had heard that all you needed to do a will was to write it up, have 2 witnesses and a notary. Is that right?
Yeah, and you'll make people like me a lot of money. So yes, in Texas, you are allowed what's called a holographic will, a handwritten will. It has to be 100% handwritten. It doesn't even have to be witnessed. It can be in your writing, signed by you. But I've not had a holographic will in the 27 years I practiced that went smoothly. There are problems with every single one of them. So yes, it's allowed. No, it's not recommended. So I have one that says I have an adult child that I have guardianship of. In a trust, will that guardianship transfer to whom I choose? No, it will not. The guardianship process is a legal court process. And in order for somebody to take over his guardianship, they have to go into court and get appointed by the judge of the court to take over guardianship after somebody. So unfortunately, that is not one of those areas where you can pass that on through a trust.
Elise wants to know, what did you say is the best way to avoid probate?
A trust. A revocable living family trust.
Okay, does the Lady Bird deed protect from Medicaid estate recovery?
Yes. If it's properly done, yes.
And Pamela wants to know, do the bank accounts go into the trust?
I recommend that they do. They're either owned by the trust or they're caught by the trust. So some banks, Chase, will not convert a personal account to a trust account. So they make my clients open up a new account. And so they have to close their individual account, move all the money to a trust account, which is a big giant pain if you have auto draft and auto pay and all that. So in some of those, I recommend that they keep it an individual account, but they list the trust as the beneficiary or the pay on death so that it flows into the trust if something happens to them. But ideally, it's best if the trust owns the accounts.
Okay. If a husband passes away and he has set up an irrevocable trust and has left all property and assets to his wife, if the wife doesn't name anyone specifically, their children, what happens to the assets and property that was originally left to the wife when she passes?
I don't know the answer to that without looking at everything. That's not one I can just simply answer without looking at what the irrevocable trust says and all that. So there's not just a set answer to that.
Okay. Is TOD recommended?
TOD, for those that don't know, is called transfer on death. Bank accounts are set up usually with POD, pay on death, TOD, transfer on death, or beneficiary. It works fine as long as everything goes exactly the way you want it to go. So if my daughter is my TOD and I die and she's healthy and alive, great, it goes right to her. If she's not, then there are problems. So if she's incapacitated for some reason and she's on government benefits, now she's got to get kicked off benefits because she just inherited money that she shouldn't have inherited. If she's passed, then it goes by way of her estate. So it may go to her estate and her estate may go to her husband, and I didn't want it to go to her husband. So when I set up a trust, I take away the TOD, POD beneficiary, and we make the trust a beneficiary so that everything flows through the trust and the trust dictates how everything happens instead of POD and TOD is by contract. And it's by contract with the financial institution that it's done with, and their rules apply.
Two things. Number one, could we advance the slides to the CEU stuff? Let's go over that. That doesn't, and because then I want to leave it on your contact information. If you'll.
And real quick, before I do that, I just want to, like this one, it says, in Texas, can a non-Texas resident be named an executor in a will for a Texas resident? Yes. That you can name an executor from anywhere. It doesn't, there's not a requirement. They can even be out of the country. Is that what you're wanting? What
it's coming. Okay, yes. No, I want to go that. I want to go back to that one as soon as we're done with this one. Okay, for those of you, go ahead, Sheila. I'll let you talk about CEU. Sorry, I spoke from you last time.
Well, now that we've answered as many questions, and I'm so sorry that I lost you for a while, and hopefully we answered most of the questions anyway. And you can always email me the questions and I can get them to Fred. Again, because I'm not an attorney. The two forms that you're going to get from Marty to get your CEUs are an eval form and a sign-in sheet. I will need those both filled out and sent back to me, and then I will be happy to issue your certificate. Very simple.
Please note that they go to Sheila and her email address is in here. I know there's ends up being a lot of confusion for some of this stuff, even though we go over it. But please, that's why we put her email address in here. Those documents go to her. That there's also a Google survey that's going to pop up, or it should give you the option to go to the Google survey as you get close out of Zoom today. But if it doesn't, don't worry. We'll also email that link in the email that we send the documents that Sheila's going to send me out to you, so that you can do both. We ask that you fill out the Google survey that helps us report back on the goals and objectives we set forth when we applied for the funding to put on these webinars. But I also want to go back real quick and say you got 1 week to do to get those documents back to Sheila. It's just too hard. Once again, it's too hard to be dealing with the certificates one at a time and having people come back a month and 6 weeks later wanting to know, wanting to send their documents in. You've got to do that within the next week in order to be eligible for those CEUs. Let's go to the one more past this, and then we'll go back, if we could. I just want to make sure you all know that our next month's webinar is going to be My Loved One Just Passed, Now What? And so join us on the 17th of October. There'll be a link in the email as well for the flyer for that one. So if you could go back to now, and then leave it there where you guys are, if you guys are answering any other questions you want to answer, or maybe you have to go.
Are there any others, Sheila, we need to wrap up?
Well, this is interesting. This is interesting. What happens to assets acquired after the establishment of a revocable trust?
What happens to the assets after the establishment of a revocable trust?
If you acquire an asset after you've established a revocable trust,
you need to align it with the trust. So it doesn't automatically align with the trust. So for instance, I get it all the time where people have their own family revocable trust and they inherit from a parent that died. You need to take those assets that you inherited and align them with your trust.
Okay. Yeah, there's 20 more questions. So
I hate to say, when all else fails, consult with an attorney.
Yes.
Yeah. And let's, if you're ready to wrap it up, do you want to wrap it up and just ask them to send the questions to you, Sheila, if you have any more questions?
Yes, please.
Yes, you guys, thank you so much. Both Sheila and both Fred are fighting some being under the weather today, and it's even been hard for me to follow the questions because there's so many. But you're more than welcome to email them to me or Sheila, and we'll answer. Get answers for the ones we can. But thank you, Fred. Thank you, Sheila. Thank you so very much.
Thank you, Marty. Thank you, everybody, for attending. God bless you all. Have a wonderful day.
Yes.
Thank you
so
all
much, Marty.
And we certainly appreciate you all joining us. Go ahead. I'm sorry,
Bye,
Sheila.
everybody.
No, I was just gonna, that was, thank you. That was it.
I thought it was, I'm sorry.
Bye, y'all.